So I'd like to welcome everybody for joining us on this Lakeside chat on an evening. We're trying something different because we know that it's an important topic that everybody is really interested in. And today we have joining us Heather West. She is currently at the Rural Law Center of New York on the base, but we've worked with her before for quite a number of years now, Heather. And I've even had the pleasure of being on a panel with her. And I know that she has great information to share with us and is very easy with the information and doesn't use a lot of technical jargon that most of us just don't understand. So Heather, I'd like to send it over to you and thank you
Sure.
very much for joining us today.
Well, thank you for inviting me. So, as Christina said, prior to joining the Rural Law Center of New York, I was the estates and trust attorney with the law firm of Stafford, Owens, Pillar, Murnane, Kelleher, and Trombley for 18 years. So I do have some experience in this area. So today I thought we would talk about trusts. I think there's a lot of information out there about trusts, but none of it is sort of the basic, what exactly does this do for me? Why do I need it? I see a lot of people come into my office, and one of the first things I hear, and I always dread it, is, well, Susie Orman says I need a will, or I need a trust. Maybe, but it's not the end-all, be-all. And certainly a trust does have purposes, but there may be other options for you, something that is faster, easier, cheaper than a trust. So I thought today what I would do is just break down the basics of what a trust is, the kind of trust that you might be interested in doing, and maybe what the alternatives are. So a lot of people can confuse what a will is, a last will and testament, is simply a document that you create that lets us, society, know what you want to happen to all of your possessions upon your death. And usually there's a process when you have a will that when you die, if you have assets, your heirs may need to go to the surrogate's court. There's the petition for probate and waivers, and hopefully everything's good and you don't need a hearing, but maybe you do. That's what a will does. That's after you are gone. A trust is something really similar to a will, and sometimes it's called a will substitute. And what it does is it is another document, and you create it either during your lifetime, and the fancy term for that is an inter vivos trust. So if somebody tells you you need an inter vivos trust, that simply means a trust that you create during your lifetime. That's it. Then there are testamentary trusts, and those are trusts that are created within your will. And those trusts do not come into existence until after you have passed away and your will has been probated. So we're just going to work basically on inter vivos trusts, so living trusts. And we'll talk about a testamentary trust because, again, there are uses for that. But basically, there are two types of trusts. Hi, Heidi. So there's a revocable trust, right? And there's an irrevocable trust. And trusts are either one or the other. There are lots of other trust names out there. There are lots of trust purposes out there. But basically, you either have a revocable trust or you have an irrevocable trust. So a revocable trust, I always kind of say this, and nobody laughs along with me, but it's like the hokey pokey of estate planning. Because you can put stuff in and you can take stuff out. Again, nobody's laughing. So I got to give up on that joke. But that's what a revocable trust is. It simply means that you can put your assets into this trust, and at any time you can take the assets back out. So why would you need a revocable trust? Why, what's the purpose of putting an asset into a trust if I can just take it out again? Well, a revocable trust has several good things about it. One, it can be a will substitute. So if you're in a situation where you want to avoid the probate process, meaning you want to avoid having to go to surrogate's court, or you want your heirs to avoid going to surrogate's court for whatever reasons, you can do a revocable trust. You can put all of your assets into it. And during your lifetime, assuming that you are the trustee, you can take those assets out if you need to. With a revocable trust, you are the grantor, meaning you're the one who created it, and you can also be the trustee, meaning the one who runs it. One of the really nice things about a revocable trust is if something bad were to happen to you, and again, like a lot of lawyers, we like to think of worst case scenarios. So if something bad happened to you and you've put all your assets into trust, you can name a successor trustee, somebody who steps into your shoes and can take care of all of your assets for you, right? It's similar to a power of attorney, which is an alternate, but we'll talk about that in a second. But certainly you get to choose who could handle those assets for you. One of the things when we talk about revocable trusts is obviously who would be your successor trustee, or a trustee if you don't want to be the trustee. I'm going to tell you who it doesn't have to be. That seems to be easier. It doesn't have to be a relative. It doesn't have to be your spouse. It should be a person who is obviously trustworthy, who can handle the kind of day-to-day, not necessarily bookkeeping, but who can keep records, who has some sense of financial situations. Now, that doesn't mean that the person you choose has to be an accountant or somebody with a fancy degree. They just need to know this is money, it's not my money, and I can't play with it, right? And your trustee can also have the power to hire other people, like accountants and attorneys, to help them. But really, it's that situation, if you're not able to take care of your assets, you're still alive, but you can't take care of your assets or you can't take care of your property, then who can do that for you? And a revocable trust is a way to kind of set that up. It's a just in case. Now, the property that you put into the revocable trust is pretty much anything you can think of with a few exceptions. So real property can be put into the trust. And when I say put into the trust, I mean that the title of the asset is changed. It's changed from your personal name. So instead of the house being in my name, Heather West's name, I put it into my revocable trust. So the deed now says the trust of Heather Dear West, dated, whatever fancy date I might choose to put on. So that's what I mean by putting an asset into a trust. You actually change the ownership of it to the trust. You can put, like I said, real property. You can put accounts. You can put personal asset, your personal property, your things. A couple of things you can't, or I wouldn't recommend, is an IRA, because that, if you put that into a trust, it's a payout, and then you'll end up, I'm sure Christina's shuddering even as I speak about this. You trip all of those lovely penalties for early withdrawals from IRAs. So those are things you don't put in. You can have a life insurance payable to a trust. So if you've got property but no cash, and when you die, who's going to pay the taxes on that? Your insurance can pay to the trust, and your trust all of a sudden has cash. One of the other pros of having a revocable trust, if you have property outside of New York, let's say you have a house in Florida or Arizona, God knows why you would in this heat, but that's up to you all. But if you have property outside, real property outside of New York, a revocable trust is an excellent way to avoid what's called ancillary probate. So, like I discussed, when you pass, you do the whole probate process in the New York court. If you own property outside of New York, real property, you have to do that process in that state as well. And that can be really time consuming. It can be expensive, and just basically a pain. But if your trust owns that property, you can avoid that. You don't have to do that because you don't own the property, the trust owns the property, and the trust is a separate entity from yourself. So you may not exist anymore, but your trust does. Another good reason to have a trust, a revocable trust, no, sorry, I just want to make sure we're staying on the revocable trust, is if you don't have a lot of family, and I know this sounds strange, but it's an estate planning technique. One of the hardest things to do when I'm helping somebody with an estate, especially somebody who has very limited family or no close family, is under New York law, I still have to find next of kin. Now, if somebody hasn't been close to their relatives in years and years and years, or has nobody, it can take a lot of time and a lot of expense to try and search for that family. And the court wants you to find somebody. So the court doesn't simply accept me saying, well, I looked and I didn't find anybody. Oh no, I have to tell them where I looked. I have to tell them who I spoke to. I have to show where I searched. This can take a significant amount of time and money. Again, avoiding probate, if you put all of your assets in a trust, we can avoid that extra cost and time. And just to kind of give you an example of how complicated this is, searching for family, I had a case where a gentleman died, worst case scenario, without a will, and no wife, no kids. But he did have 6 brothers and sisters, a mother who had predeceased him, and a father who disappeared 50 years ago. Now, nobody had heard from the father in 50 odd years, but rumors were he was still alive, still in, not New York, but they thought New Mexico. Great. I had to prove to the court, I searched, and what the court does then is after you've done your search, the court says, well, one last shot, you have to publish a notice in a newspaper and where you think the last place they lived is the last resort. I don't like doing it. It's expensive, time consuming, all of those bad things. I did publish in New Mexico in the county where I thought this person was. It was so rural that they didn't have a daily newspaper. They didn't have a weekly newspaper. They had a once a month newspaper. And so the judge was very gracious and allowed me to print in that paper. One day after publishing the notice, I got a phone call from my client, and lo and behold, after 52 years, the father is in New Mexico, alive, doing well, and has 6 other kids, which means I now had to give them notice. Well, some of those 6 kids had died. Then I had to track down their kids. Some of those kids were adopted. I got to track down those kids. My client was fortunate in that I did this as part of the Rural Law Center, so the service was free. Easily, if I were a private attorney charging, I'm looking at probably $8,000 to $10,000 in fees just to help her find her family. So that is an extreme example, but that does happen. It's happened to me more than once. Yes.
How far down the line do you have to go? You know, do you have to find cousins? What's the rule?
First cousins once removed.
First cousins once removed.
Yep. So basically great grandchildren of the common grandparent. So yeah, it can go down pretty far. And like I said, it happens. It's happened to me more than once. And it's always the person who has supposedly no family, and I'm the one who discovers that they had like 32 cousins, who all of a sudden have a right to object to that person's estate. So speaking of which, that leads me into the next reason to have a trust. If you are having issues with family members, or let's say a family member maybe has maybe a drug problem, a drinking problem, a gambling problem, maybe they married the wrong person. A trust is a way to protect those assets from that person. A will gives them an opportunity to object to it. You know, all of those lovely nighttime dramas where somebody's going to object to the will and all of that good stuff. In real life, it's a good $20,000 to do a will contest, I'd say. It's super ridiculously expensive. But that doesn't mean somebody can't trip up the estate and drag it out. So if you want to avoid some kind of family conflict, a trust is a way to avoid the surrogate's court. Now, I've been talking about trying to avoid the surrogate's court and probate and all of that. In and of itself, probate is simply a process. It is neither good nor bad. I think it depends on your situation. It depends on your family and your circumstances. So again, when we talk about maybe you want to do a trust, you need to talk to whomever it is you're working with and ask them, you know, am I going to be better off with a trust, or is there really any need to set that up right now? Can I just do a will? What makes sense for my situation? And I think that's why I always have a problem with the whole Susie Orman thing, is it doesn't take into account what your situation is. It shouldn't be a blanket recommendation, in my opinion.
Yeah. Heather.
Yes.
We often get a question of, is there a certain level of assets that somebody should have before they consider a trust? Is there a guideline there?
There's not really a certain level, but trusts do cost money to operate. So you want to make sure that if you have a trust, there's enough money in there to make sense to have a trust. Because depending again also on how long that trust is going to exist. So with a trust, and this is general, either revocable or irrevocable, doesn't matter, the trust at some point is going to pay out to your heirs. And that may be immediately after your death, or it may be 20 years after your death. So I think when we look at creating a trust, we also have to keep in mind not only what are the assets going into it, but how long do we expect this trust to last? So if you're just thinking of putting $50,000 in a trust, that might make sense if we're looking at maybe having a minor eventually get that money, and you know they're 15 now and we want it to pay out when they're 21. Okay. But if you want that trust to last their lifetime, that $50,000 isn't going to do anything. It's going to get eaten up by the trust, because there are going to be fees, because you've got to pay the trustees. There are probably going to be bank fees, taxes, depending on what kind of trust you've set up. So I think, again, when you're doing a plan, you need to look at what am I putting in there and what realistically, how long is this going to last?
That makes sense. And
That's
Dolores,
why it's hard to tell how much.
yeah. Dolores, did you have a question? No, maybe not. Heidi has a question.
Yes, part of the thoughts would be too is it depends on the composition of your assets. And you alluded to it earlier. If you have an IRA, you have to make special provisions.
Certainly, and I think also if all you're putting in the trust is, say, your house, so yeah, the house may be worth $200,000, but you have cash in that trust to pay the land taxes and the insurance, and again, the trustees fees. So again, that's why we need, you want to seek advice. A trust isn't certainly something you would do on your own if you don't have, haven't spent 3 years in the hell that is called law school and passed bar. It's not something I recommend trying yourself. I have run occasionally into a client who's got a trust document off the internet, and it's not pretty. It's not pretty at all. But certainly seek advice. And I think that way you'll have a better idea of what your goals are. So, and I'm just checking my notes here to make sure, no relatives. So again, another pro of having a trust, if you have an illness, let's say you've been diagnosed with some illness that right now is maybe at the beginning stages, but it's going to progressively get worse. So again, kind of going back to that idea of if anything happens to you, who can help you and take care of those assets for you. Now, the one thing I will say with a revocable trust is that there is no tax benefit to it. Now, I'm talking about a revocable trust. Because really, a revocable trust, if you're not only the grantor but the trustee, you still control the assets, and that's all the IRS cares about. If you have any control, it's still your asset in their eyes. So there's no tax benefit to it. On the other hand, there are certain types of irrevocable trusts that may have a tax benefit. So kind of, that's the summary of what a revocable trust is. So before I move on to an irrevocable trust, does anybody have any questions?
I think that's a great timing for questions. Go ahead, Heidi.
Yeah. I would just say a comment on the irrevocable trust, maybe because you alluded to if you have pre-existing health conditions that could get worse. I like to see people establish them as a conduit so that in event they can no longer manage their assets, they've put in place the cast of characters to help them.
Yep.
Though there's no tax benefits on the rest of your lifetime management, I think it really matters to have people you trust helping you.
Absolutely. Absolutely. One of the harder things is trying to explain to a client after some kind of catastrophic diagnosis or event that I can't help after that. Because in order to make all of these documents, whether it be a will, a trust, a power of attorney, the person has to have capacity. They have to have an understanding of what's going on. And if you have suffered, say, a massive stroke, you are in a coma, I can't help at that point. It's too late. So with any type of estate planning, we plan for worst case scenarios in the hopes that we don't have to use them. But, the reality is sometimes you do. Sometimes, certain things happen. One of the examples I always give, and only because this isn't for sympathy, but it is, to me, the perfect example, and probably because, this was my family, so I made sure everything was in line. One Friday night, my mother had a horrible headache, and thought she had the flu. She woke up Saturday, wasn't feeling well, so I went to the store to get ginger ale and crackers, because that's what you do when somebody's not feeling good. When I came back, she still wasn't feeling well, and her eyes were listing to the left. And I thought, oh my God, I think she's had a stroke. So off to the ER we go. And many hours later, the ER doctor then tells me my mother has a malignant brain tumor and she has brain cancer. This happened within a span of, let's say, 12 hours. From Friday night to Saturday morning, everything in my family's life changed. Now, as you can imagine, none of us, my brother and sister and I, none of us were thinking straight. None of us were even remotely had an idea that this is something that could happen to us. Throughout the next 8 months, as she went through treatments and progressively got worse, one of the things that struck me was I had prepared a power of attorney for her. I had a healthcare proxy for her. My brother, sister, and I knew what her wishes were. We had everything in line. And I have to say, in all of those 8 months, there wasn't a moment where I couldn't just handle something without having to worry about fighting my brother and sister, or about having to worry about going to court to get guardianship, or, dealing with whatever paperwork, because I had all of these things in place. And that's what any of these documents do. Whether, like I said, whether it be a trust, a power of attorney, a healthcare proxy, that's kind of an aside, but still. There was no warning. My mother was perfectly healthy, and then literally woke up the next day with, a diagnosis that eventually would lead to her death. And so it's a harsh example. And I say this only because I know people always think, well, nothing bad's going to ever happen to me or my family. It does. It can. And so the best thing you can do to protect you and your family is have this stuff in place. Get advice, go to professionals, get things set up. And, hopefully you never have to use it. But if you do, trust me, your family is going to be thrilled you did, because they don't need the added stress. So that was an aside. Sorry about that, but that's just the example I always use to kind of pound home the point about how important it is to have these things in place.
Well, thank you for that, Heather. Appreciate
that. On my lovely tangent.
Well, actually, I have a couple follow-up questions.
Yes.
So one has to do with your mother. If she had not had those documents in place and she's diagnosed with a brain tumor, would she have been able to execute those documents at that point?
Given her condition, not immediately afterward. There may have been a period, there were a couple of months where her capacity was fine and she could have, but certainly not immediately.
Okay.
I'd say for the first month, absolutely not. She'd had major surgery between the chemotherapy and all of that stuff. Her capacity, she was aware and knew what was going on, but her short-term memory was shot. She had none. Okay. So to me, that wasn't an indication of capacity. And certainly towards the end, absolutely not. There was no recognition, there was no memory, nothing. So fortunately, like I said, this is what I do for a living, and I can't preach to you all about having these documents in place if I didn't have them in place for my family.
Right. Yeah.
So that's why it's so important to have these sorts of things in place to begin with, because you don't know.
No, we run into it all the time.
Yep.
It does tend to be something that people procrastinate about. Nobody wants to think about it, and we try to drive home how critical it is to get your affairs in order so you don't have to think about it again.
Yeah, and that's why I give that example. I know it's probably more personal than most professionals would give, but simply because it is exactly what you would want to happen if you're going to be in a really bad situation. That's exactly why you have a power of attorney. That is exactly why you have a healthcare proxy. If my mother had money, I'd have had a trust. If she had assets, we would have put them in a trust. So yeah, it's just the best example I have, and it's because people see me. It's a real thing. It's not something that I made up, so to say. So could you excuse me for one moment?
Yes, absolutely.
Hold on 1 second.
Anybody have any questions out there for when she gets back?
No, but I have something to say. This is Brenda.
Hi, Brenda.
Hey,
Hi,
Brenda.
everybody. When we came to Heidi, she said, I'm not going to work with you if you don't do these papers. Go get them done before you come back. And that was the best advice we ever had. And Heather, your story really brings that home. So thank you very much for that.
You're welcome.
Thank you, Brenda.
Had to go unlock a door so my sister could get into the house. Sorry about that.
Oh, that's so funny. You locked her out. Heather,
Her out. So
everybody always wonders, how much do estate documents cost when you go see an attorney? And I know there's a large range, but It seems to be a pretty popular opinion or question. And then you can always talk about what the Rural Law Center is doing right now.
Certainly. So typically, if you do the basics, let's say a will, power of attorney, healthcare proxy, depending on how complicated it is, it could be anywhere from, let's say, $600 to $1,000. I do know that, again, depending on where you're going, it could go up to a couple thousand for sort of the basic things. I think it depends on what firm you're going to. The more complicated, obviously, the more expensive. If you're talking about a trust, probably a couple thousand for that. But again, if you've got assets to protect, even though it sounds like a lot, it will be well worth it if you've protected them. And again, if something bad happens, that $1,000 is going to be nothing compared to how good or bad things run if something happens to you. So I don't, trust me, I don't make light of the fees. But, and since you brought it up, I do work at the Rural Law Center. We are a not-for-profit. We help low-income New Yorkers in any of the 44 rural counties of New York. We offer free legal services, whether that be consults or paperwork, including drafting wills, powers of attorney, healthcare proxies. We do have some grants with the local Office of the Aging with Essex and Clinton, where we don't have to take into account your income level. We can't do anything super fancy. I can't do any trust work because that's just way beyond the scope of what I can do at the Rural Law Center, but certainly wills, powers of attorney, healthcare proxies. If you have questions, I can certainly help with that as well. And it's not limited to just estate planning or estate administration. We do landlord tenant, consumer, bankruptcy, pretty much the whole gamut. If you're in a criminal matter, we don't do that. And we don't do litigation because I cannot drive all over New York State to show up in court for anybody. So that's our limitation.
Now, with those grants, there was an age.
60 and above.
Yep. And I know that Heather helped my grandparents just last year. They are in their 90s and they have never had anything written up or drafted, and I've been telling them for years. And they finally listened and went and saw Heather, and they absolutely loved the entire process. And she was great with them.
Thank you.
It really was wonderful.
Heather is a rock star.
Oh, thank you. So are there any other questions about the revocable trust part? Okay, so we're going to talk about irrevocable trust. So where the revocable trust is the hokey pokey of estate documents, irrevocable trust is the opposite. It's where you put assets in and they don't come out until a triggering event. So if you put your house in an irrevocable trust, it should not come out, usually until after your death, and it's going to an heir, which is, so your death is the triggering event, or maybe a certain time frame. Depending on why you're doing an irrevocable trust, you may be the grantor and the trustee, or you may not be the trustee. Again, it depends on what you're doing it for. So, like I said, an irrevocable trust, it still serves all of those purposes that I just told you about, but there are a couple of different advantages. One, there may be tax benefits to it. Now, this was a bigger issue when we had to worry about estate taxes. When estate taxes were down to $1 million, even when they were down to $5 million, there may have been some clients who could benefit from an irrevocable trust. And again, depending on the type of an irrevocable trust. These days, with the estate tax credit at 11.54, a lot of us are not going to be worried about estate taxes anymore. And certainly not if you're coupled, because you can double that and you get almost $23 million worth of estate tax credit. So the purpose of that is probably gone to the side. But there are other reasons, and there are two really popular irrevocable trusts. One is for Medicaid planning, right? And the other is something called a supplemental or a special needs trust. So I'm just going to give you kind of an overview. These are types of irrevocable trusts. There are probably 1,000 different types of trusts because there are 1,000 reasons to have a trust. It's all what, again, your situation is. But the two most common, I'd say, are Medicaid and supplemental needs. So a Medicaid irrevocable trust is where folks are trying to protect assets. So in the event that they should need nursing home care, their assets are protected from what's called the Medicaid spend down. So just to kind of, and you have to kind of always backtrack, Medicaid is a program, it's a state and federal program, that can pay for nursing home care if you meet the income guidelines. Usually, though, these guidelines are towards the lower income and lower assets. So if you need nursing home care, it is astonishingly expensive. I'm sure you all know this, but just to kind of give you some sticker shock, I'm thinking $12,000 a month for nursing home care. So again, unless you're in that $11 million field, good for you. Most of us, though, aren't going to be able to afford that kind of money, not without running through our assets, right? People have spent their lifetime building up these assets, and they don't want to give them up. They want to make sure that their assets left for their heirs, that's what they've worked for. They want to make sure that their family is taken care of. But that's hard to do if you're going to need nursing home care. One of the first rules about Medicaid that I tell every single one of my clients when we start talking about this is the first rule is Medicaid does not want to pay for you, right? Sadly, that's just the way it is. And if you keep that in mind, then everything else that follows sadly makes sense. In order to protect your assets, you can't own your assets. I know that sounds strange, but welcome to the world of Medicaid planning. What you could do, and there are so many factors that play into this, so it's so hard, but if you were to put your assets into an irrevocable trust, meaning you can't get those assets back out, and you are not the trustee, meaning you don't control those assets, and you time it just right, if you then applied for Medicaid, you might be able to not even include those assets when you're talking to them about what available assets you have. So the biggest trick with Medicaid is there's this thing called a 5-year look-back period. And I'm not sure, I don't know how many of you are familiar with this, so I'm just, again, if I'm explaining things you already know, I apologize, but I just want to make sure we're all on the same page. For Medicaid purposes, when you apply for Medicaid, they look at the assets and the income you have at the time you apply, and they look at the things that you had 5 years prior to applying. So why are they doing that? They're looking to see if you transferred or made gifts within those 5 years. If you did, and even if you don't have that asset any longer, you gave it away, they're still going to count it against you, right? So that 5-year look-back period is the opportunity for Medicaid to take a look at your finances and say, oh, look, you gave away $120,000 2 years ago. Well, you could have used that $120,000 to pay for your care. So we're still going to count it against you, even though you gave it away. What happens then is they take the value of that gift or that transfer and they divide it by whatever the monthly regional rate is for nursing home care, their version of what the monthly cost of a nursing home should be. And because I really suck at math, I'm going to say let's pretend it's $12,000. So you made $120,000 gift. The regional rate is $12,000. You divide that into the 120, you come up with 10. 10 months is the penalty period. The penalty period is the time frame that Medicaid says, yes, we're going to accept you into our program, but we aren't going to pay for the first 10 months. That's the penalty period. So those 10 months, you're going to have to pay for out of pocket. This is all timing. So what a Medicaid trust does is you put all of your assets, the ones you want to protect, into this trust, hope, pray, take your vitamins, and if 5 years and 1 day you have to apply for Medicaid, as long as you are 5 years plus 1 day from the time you made those transfers into the trust, they can't touch those assets. They no longer count them as the look-back period, meaning then you don't have a penalty period. So the problem with the Medicaid trust, as I said, though, it's all timing. You don't know when you're going to need nursing home care, hopefully never, right? But if you do, have you timed it right? Did you, or do you have enough in other assets to make up for the penalty period? So if you gave away $120,000, do you have another $120,000 somewhere that can cover those 10 months that you're going to be in the nursing home with no Medicaid coverage? So the point of the Medicaid trust was to try and protect some of those assets so that when you passed, Medicaid couldn't, look back on your estate and say, oh, look, you still have money. We want to be repaid, because Medicaid can do that. And they also can't count it against you as an asset. So if you've given enough away, you may qualify under their whatever guidelines there are that year. All right, so that is kind of a basic Medicaid trust. It's definitely something you want to do with a professional. It's difficult not to do in and of itself, but for many of my clients, the idea of not only giving up their assets, but giving up control over those assets is really difficult. And there's always the possibility that you may never need Medicaid, and you've then taken those assets out of your reach, so to say. With a Medicaid trust, as with any trust, you yourself, if you are the beneficiary, you do get the income earned off of the trust. And that income, of course, for Medicaid purposes is countable. So even if you beat the 5-year look-back period, if your trust is paying you the income from whatever assets you have in there, that income is still counted. But at least you've protected your other assets. A lot of times that may be the house. So you may not actually be getting any income off of that. That's one of the more popular irrevocable trusts. So again, like I said, it's kind of scary because you're giving up those assets and you're giving up control. But if you have assets that you want to protect and yet still qualify for Medicaid, that's the route you take. And like I said, there may be another option. I'm going to talk about that in a minute. The other more popular irrevocable trust is, do you have a question? Oh, you're on mute, so I can't.
Becky or John, looks like you guys have a question.
Yes, yes.
Go ahead. Oh, here, let's unmute you. Here we go. Can you unmute yourself, John?
Yeah, can you hear me?
There you go, yeah.
Okay, so can they force you to sell your primary residence?
No. That, I think what happens is people are so afraid that Medicaid is going to make you sell your house in order to qualify for Medicaid. That's not true. There is something that does happen, but that's not what happens during your lifetime. As long as you are living, they aren't going to make you sell your house. Or even if you go into the nursing home, but your spouse is still what they call in community, meaning you're not in the nursing home, they cannot make you sell your house. And it may be part of an exception, meaning they won't touch it at all. What can happen is if during your lifetime you have used Medicaid and you pass away and you have assets, you have an estate, meaning you're in surrogate's court, they can put a lien against your estate. And in order to pay that lien, you may have to sell the house in order to pay them back. That's where losing the house, so to say, comes into play. So if you're looking to save it for your kids, there's another option we're going to talk about. But that's what happens. But during your lifetime, no, Medicaid's not kicking anybody out of their houses. Not at all.
Interested in whether our kids would
Well,
still get it. Okay.
sit in on the conversation because I'm going to talk about that in a second. Okay, so any other questions about that? I know it's kind of specific for that trust, but nope, okay. So a supplemental needs trust, or sometimes it's called a special needs trust. When you have an heir or a beneficiary that is disabled and has Medicaid, you should not leave them assets outright, whether it's in your will or your trust or giving them gifts. Because what happens is if they get income a gift, cash, Medicaid counts that and it could destroy their benefits. It could wipe them out and get them kicked off Medicaid. Most of the time, there's no gift that's worth getting kicked off of Medicaid, right? But so what would happen is when people would do estate planning or do a trust, they'd hate to do it, but they wouldn't leave their child who had a disability and had Medicaid. They would basically disinherit them just to make sure that they didn't get kicked off Medicaid. The way to avoid that is creating a supplemental needs trust or a special needs trust. And you can do this, it is an irrevocable trust. You can do this during your lifetime, the fancy inter vivos trust, or you can do it in your will. You could create a testamentary trust. But in any event, what happens is whatever assets you're putting in there for the disabled person, they go into an irrevocable trust. You have a trustee, not the beneficiary, who can then use the income, or if necessary, the principal from that trust to pay for things that are not covered by benefits, like vacations, or maybe clothing or rent. The beneficiary themselves never has control over the asset. And because they don't have control, Medicaid does not touch it. Now, there is a supplemental needs trust where Medicaid can get the remainder after the person dies, but that's usually what's called a first person supplemental needs trust, meaning the disabled person themselves set it up. Usually, a lot of the times I see it, so like I see Christina's got a question on her face. So if, let's say a person suffers a terrible accident and becomes disabled, they can take a settlement and put it into a supplemental needs trust for themselves, or their parents can. Third-party supplemental needs trust, somebody else is making that trust for the person. Usually maybe a grandparent, aunt, uncle, even a parent can set up a supplemental needs trust in a will. But that way you haven't disinherited that person. They're still going to get the benefit of the asset, but you don't endanger their benefits. And then after they pass away, the trust will pay out to whomever you want it to, whether it be your other children, other heirs, charity, whatever you would like it to be. So basically, that's what irrevocable trusts do. I mean, you put the assets in there, they're protected. It's not that different for purpose-wise from a revocable trust. Same reasoning, you may want to create an irrevocable trust for your protection of family members. Like I said, those special cases where maybe you have Medicaid planning or a disabled person in your family you want to protect. Any of those may be good options, or maybe a trust may be a good option for those things. So any questions about irrevocable trust? I kind of stuck to the two specific ones, but like I said, there are dozens of reasons to have irrevocable trusts.
Anybody have any questions? I have a couple. Go ahead, Heidi.
I would just make a comment that people often will do this with legal counsel and they won't consider the income tax consequences. They'll fail to file a gift tax return, and then the person setting this up and gets a boomerang. So I think there's a lot of dangers of doing irrevocable trusts, in that you're giving away an asset, and it's usually a taxable event.
Right. Well, for gift tax purposes, I mean, there are 1,001 taxes. Again, we can use part of that estate tax credit because it's twinned with the gift tax. So that 11 point whatever federal $1 million credit that we have, you can also use that for gifts. So a lot of times, though, you're right, people forget to file. I mean, they may not have to actually pay anything out of pocket, but you still have to file.
Correct.
And just as an aside, you can make gifts up to $15,000 per person to everybody you know in the world. You don't have to file a gift tax return. 15,001, you've got to file a gift tax return and just use some of the credit.
So Heather, actually, one of my questions had to go with that $15,000 a year gift tax. when they look at when Medicaid looks at what you have for assets now and what you had for assets 5 years ago, and so you've been gifting $15,000 a year to a child, does that count against you, or do they allow that?
Nope.
Okay,
It counts
because
against you.
often a client has a conversation with an attorney and they're under the impression that they're allowed that free $15,000 a person per year, and
Right.
that will not be counted.
For Medicaid purposes, it is counted. For tax purposes, it's not.
Okay, perfect. Good to know.
Yeah, oh no, anything gets counted. And because Medicaid asks for copies of all of your bank statements, I mean, this is what the pain about applying for Medicaid is. You've got to have your finance copies, you've got to have your bank copies, your statements, all of those things. If they see something that looks suspicious, they're going to call you on it. And certainly, and I agree, I've seen clients do that or maybe they neglect to tell me because they think, well, I don't have to pay taxes on it and I do it every year. Nobody's ever said anything to me, so she doesn't need to know I've been doing this for 20 years. Yes, I do.
Adam,
Yes, you did.
question?
Yeah, I did. I've seen a few irrevocable trusts where the grantor is also the trustee, and most of the benefits that I've heard of come from when you're actually giving up control and you're not the trustee in that situation. So when would you do something like that?
Be the trustee or not the trustee?
Be the trustee, even though it's irrevocable.
If you're not worried about Medicaid and you're not the supplemental needs beneficiary, if you're not looking for a tax break, again, for estate tax purposes, that, again, reasoning because the tax credit is so high, that's kind of fallen by the wayside. But if it's not for Medicaid purposes, you can be the trustee. You can.
Just seems like a funky way of doing it.
Yeah, why not do the
does.
revocable?
It does. I mean, why would somebody put something into an irrevocable trust but still try and control it? I would say family issues. And again, depending on what the asset is. Like if you've put your interest in the family business in a trust.
Doesn't that make it defective?
The family.
If you have an irrevocable trust and you maintain incidents of control, doesn't that make it defective as irrevocable?
No, because, and again, depending on why you're doing it, if you can't remove the property, right? So let's say I put a house in there, I'm still the trustee, I can control the house, I can sell the house, but I don't ever get those proceeds back out.
I see.
Unless there's a triggering event. So the asset itself, if it remains in the trust, I think that's probably the bigger concern. I have a lot of people who will do that. They'll put a house in the trust, decide, you know what, I'm sick of living here, I want to live somewhere else. They sell the house, and for some reason they think, oh, I can just take the money back out. No, you can't. Not if it's an irrevocable trust. The money stays in the trust. What you can do is if you're the trustee, you can take the money from the trust, buy a house for the trust, and depending again on what the terms of the trust are, you may have a life estate in any of the real property contained in the trust. So yeah, you still control it, but you don't necessarily own it and you don't get your money back. So that becomes a problem if somebody's looking to buy something in their own name.
Sure. Thank you for clarity, because people do that and they don't understand. Thank you.
And again, it all depends on the purpose of the trust, why you're creating this trust. So if it's a Medicaid thing, then yeah, if you're the trustee, you've blown it already.
So we have about 5 minutes left. I know you wanted to talk about life estate real quick, but does anybody have a question? Brenda, do you have a question?
I do, yes. Oops, I unmuted. Yes, so say you're living on some of your assets, do you not put those in? You only put the ones in that you don't need to live on because you won't get anything back once it's in there.
You still can make yourself the beneficiary of your own trust. And if you're the beneficiary, you can get the income earned off of that trust. It's payable to you. So again, I wouldn't I would never do anything that endangers my current standard of living. So if you do have assets that you're not using, those would probably be the first things I would put in the trust. But, you know, sometimes people, you know, if you're looking to put in a savings account, but you're going to want to use that cash to pay for something, then I wouldn't put that in the trust. It doesn't make any sense if you're just going to try and take it back out. So yeah, I would be careful about that.
So the fees that you were talking about might be $2,000 to set up a trust. But then there are yearly fees, annual fees beyond that.
Yes, there are trustees fees because the trustee is what's called a fiduciary position. They can be paid to act as the trustees. Normally people are either going to be their own trustees, depending again on the type of trust, or a family member's going to be the trustees, so they're not really going to take any fees. But certainly you can hire professionals to be the trustees, and they're going to definitely have fees. Like a bank, they're going to want to be paid. You'll probably have attorney's fees throughout the lifetime of the trust. Likely you'll have accountant fees. Depending on the size of the trust, you may have planner fees and financial advisor fees. So yeah, there are all sorts of fees. And again, when we were talking about the size of the trust, these are the things you take into consideration.
Thank you. Maybe you answered all those before. We came a little late. I'm sorry, but thank you, Heather.
Brenda, you're perfect.
Okay.
You're great. John, do you have a question? Or did Becky have another follow-up question?
You mentioned IRAs and 401ks and that type of thing, where your life savings may still be in that medium. Does that preclude you from having a trust, or you keep it out of the trust, or?
Keep it out of the trust. You can have a trust for whatever purpose you want. And nothing, there's no, not to my knowledge, there's no sort of an account that stops you from having a trust. You may not want to put things in that trust, but you can certainly have a trust.
And actually, sorry to interrupt, with IRAs, they have to be in the name of an individual. When it comes to trusts, there might be an instance where you can name the trust as the beneficiary of that. But like Heather said, it starts getting complicated and there are other issues involved.
Yes. Yeah. So just in these last few minutes, I just want to kind of briefly tell you about a couple of other options instead of doing a full-blown trust. If controlling the assets is your concern, if you think, you know what, if I get sick in the future, who's going to be able to help me control all these assets? Instead of a full-blown trust, you may want to do a simple power of attorney. That is a document that you can do. It's relatively straightforward. It's for financial assets. You name a person or number of people, depending on who you want to name, who can act as if they were you in certain financial situations. The kind we do is called a durable power of attorney, meaning it's good when you have capacity or when you don't have capacity. And the best example I have of that, so why would you have one and not the other? If you travel a lot, you may be perfectly fine and healthy, but maybe you're in Canada and you're selling your house and somebody needs to sign for your property here. So even though you have capacity, you need a power of attorney so that somebody can sign on your behalf for the sale of the house. Really, the kicker is if you lose capacity. A power of attorney allows the person that you've elected to act as if they were you for bank accounts, for your stocks, bonds, basically dealing with insurance, anything like that. A power of attorney is a good alternative. It's usually a lot less expensive. I think I used to charge like $50 to do one when I was with the law firm. The other option instead of a trust is if you're interested in giving the house or real property to your children, if that's the primary purpose of trying to protect the asset, you could do what's called a life estate instead of a trust. A life estate is where you give the property to whomever it is, but you retain the right to live on the property for the rest of your lives or to use the property for the rest of your lives. You still pay the taxes, you still pay the upkeep, the insurance. Nothing really changes for you as the owner. But once you pass away, that property does not go into probate because there are owners. You've given the property away, and they automatically own the property upon your death. And it takes it out of Medicaid's reach. For a lot of Medicaid purposes, a life estate is the cheaper and, again, faster way to do this. You're still protecting the asset. You still face a 5-year look-back period, just like you would with anything else. But even after you pass away, Medicaid cannot put a lien against the property because you don't own it at time of death. Yes, ma'am, Miss Heidi.
If you maintain a life estate, there is a value of that life estate. So Medicaid can't attach on the value of the life estate. Sometimes the value could be quite high.
If you were to sell your life estate, then yes, they would. I've never seen anybody do it though. So as long as you're living on the property, Medicaid's not going to touch it. They really aren't. I've never seen them do it. I suppose technically they could, but really in the 20 years I've been doing this, I've never seen them go after a life estate. I think if you actively sold your life estate, so it happens. I have never seen it done, but let's say you live you have a fabulous piece of property. You don't want to live there anymore, but you have a life estate, so you rent it out to somebody for the length of your life estate. Medicaid can attach that. That they'll go after. Never seen it, but who knows? Yes, Adam.
So say you have your plan in mind and you say, I love this house, I'm going to stay here forever, and then for some reason you change your mind after you've done the life estate and you find another house that you fall in love with and you want to sell your current one that has the life estate and move to a new place. What would happen in that instance?
So here's the tricky part about a life estate. You don't get to sell it without permission. It is not, because again, remember, you don't own the house outright anymore. You own an interest in the house.
Sure.
So if you gave your house to the kids and the kids really want to keep the house and they say, no, we don't want you to sell the house, that's it. That's it. You cannot force them to sell the house. Just as they can't force you to leave the house, you can't force them to sell the house. And if you sell the house for tax purposes, all you are entitled to is your prorated share of the sales proceeds. So your portion of the sales proceeds is going to be the equivalent of the worth of your life estate. And that involves IRS tables and life estates, and it's horrible. But your kids technically get they get the remainder money. Okay. So when you think about doing life estates, again, it is one of the things I talk about. You had better be sure you are never leaving that house. Because I do see this occasionally. Somebody will give the house to a child and the relationship then breaks down and they want to take back the property. Not unless the child's willing to give it up. So, things to keep in mind.
They also may lose discounts they get for VA. And all of a sudden they'll have increased tax expenses.
Yeah, if you retain a life estate and that house is your primary residence, you do still get to keep your star exemption and your veterans exemption because it's whoever the primary residence of the person living there. They're the ones who get the tax benefit. So your kids aren't going to be able to claim a star exemption on your house. They should really claim it on theirs. But you do still get to keep your exemptions, even though technically you just own a life estate. And again, with any of the stuff that I've talked about, each person is different, each case is different. What applies to somebody may not apply to anybody else. That's why you have to talk to professionals.
What, you don't mean call up Susie Orman and get a one-size-fits-all?
You know what? All of you are unique, and all of you have different perspectives, different interests, different goals. And so this is just very general, basic information for you all. And I know I've spewed out a lot of stuff, and You know, there's a lot of things to consider. I do think, though, it is a good thing to, you know, you all are interested, you've joined this webinar. It's a good starting point, these kind of conversations. And please feel free to, you know, if you qualify for the Rural Law Center, feel free to reach out to us. If you have attorneys or other planners, somebody like that, feel free to discuss this with them. I really do hope that everybody has an estate plan in place, because again, you don't know what's going to happen. You don't know when time is done. And for most of us, I think we want to, as best we can, protect and help our families, even when we're no longer here.
Very well said, Heather. John?
Carol, do you have any questions? Carol? Oh, she's muted if she does.
Yeah, she can unmute herself if she wants to. Does anybody have any questions at all?
And as always, I have spoken over the length of time. Sorry, folks.
That's okay. That's
Oh,
okay.
it was great. That was really good. Thank
I
you.
always get on a roll with this sort of thing.
You know what?
Wealth of information.
Oh, Pat Heffernan is giving a clap. Thank you very much, Pat. One last final question. We have a document, say a living will, that has a date on it and it's crossed off and somebody puts in a new date without initialing. Does that void it?
A living will is, now when you say a living will, are you referring to something about health care, or are you talking about a last will and testament?
No, the healthcare, the healthcare.
In New York, a living will doesn't have a statute behind it, unlike a healthcare proxy. So a living will that has a date crossed out, I'd be hesitant. It's certainly, again, if it doesn't name an agent, somebody who can make decisions for you on your behalf, I'm probably not going to pay that much attention to it. It probably would be good to give guidance if there's a question as to what treatment should be given. The courts do allow that. You know, so if it says, you know, if I've suffered a heart attack, I don't, you know, DNR me, I don't want anything. And if a decision has to be made, that can be evidence. But living wills, like I said, there's case law behind it. There's not an actual law about living wills. There is for healthcare proxies.
Good to know.
Yeah, Heidi.
Go ahead.
Yeah, I'm new at this and I was trying to unmute myself. But I lost the internet connection because we had a thunderstorm as usual, and you know, this kind of weather. But no, I'm fine. I have no questions.
Well, then I would like, oh, John?
No, I was just going to say thank you very much. Very informative.
Thank you.
Yes, yeah, thanks. It was.
Thank you.
Yes.
Thank you.
And Juanita?
Thank you very much. This really hit close to home, so thank you.
Good. Thank you, Attorney Heather Dear West. We appreciate you taking the time to come and talk to us today and providing so much information. We almost could do about 5 more of these and still not cover everything.
And sadly, I could speak at length on all of those.
No, it's not sad. It's excellent.
All right. Well, thank you all. We will let you go. Hi, Becky in the background.
Hi, I've been off to the side listening. It was very interesting.
Good, good. I'm glad. It's great seeing everybody, and we'll let you know when the next Lakeside chat is, and we are happy to hear if you guys have any suggestions or need to know anything, and we'd be happy to set something up. Thank you for attending.